Welcome to part 2 of episode 44. In part 2, we continue to deal with the judge's rules, and as mentioned in part 1, that the judge's rules are administrative directions. 2, that they do not have the force of law, but as good practice they should be adhered to, and if not, a judge or trial could exercise his or her discretion in excluding evidence or statement taken contrary to the spirit and letter of the judge's rules. Now, this is part 2, which is entitled Administrative Directions and Interrogation and the Taking of Statements, and it refers to the procedure generally. 1. When possible, statements of person under caution should be written on the forms provided for the purpose. Police officers' notebooks should be used for taking statements only when no forms are available. 1B. When a person has been questioned or elects to make a statement, a record should be kept of the time or times at which during the questioning or making of a statement there were intervals or refreshments was taken. The nature of the refreshment should be noted. In no circumstances should alcohol drink be given. C. In writing down a statement, the words used should not be translated into official vocabulary. This may give a misleading impression of the genuineness of the statement. D. Care should be taken to avoid any suggestion that the person's answer or answers can only be used in evidence against him, as this may prevent an innocent person making a statement which might help to clear him of the charge. 2. Record of interrogation. Rule 2 and Rule 3C demand that a record should be kept of the following matters. A. When, after being cautioned in accordance with Rule 2, the person is being questioned or elects to make a statement, of the time and place at which any such questioning began and ended, and of the persons present. When, after being cautioned in accordance with Rule 3A or B, a person is being questioned or elects to make a statement, of the time and place at which any questioning and statement began and ended, and of the persons present. In addition to the record or records required by these rules, full records of the following matters should additionally be kept. A. Of the time or times at which cautions were taken, and B. Of the time when a charge was made and or the person was arrested, and C. Of matters referred to in paragraph B above. If 2 or more police officers are present when the questions are being put or the statement made. The records made should be countersigned by the other officers present. 3. Comfort and refreshment. Reasonable arrangements should be made for the comfort and refreshment of persons being questioned. Whenever practicable, both the person being questioned or making a statement and the officers asking the questions or taking the statement should be seated. 4. Interrogation of children and young persons. As far as practicable, children, whether suspected of a crime or not, should only be interviewed in the presence of a parent or guardian, or in their absence, some person who is not a police officer and is of the same sex as the child. A child or young person should not be arrested or interviewed at school if such action can possibly be avoided. Where it is found essential to conduct the interview at school, this should be done only with the consent and in the presence of the head teacher or his nominee. 5. Interrogation of foreigners. In the case of a foreigner making a statement in his native language, A. The interpreter should take down the statement in the language in which it is made. An official English translation should be made in due course and be provided or proved as an exhibit with the original statement. The foreigner should sign the statement at A. Apart from the question of apparent unfairness to obtain the signature of the suspect in an English translation of what is said in a foreign language, can have little or no value as evidence if the suspect disputes the accuracy of this record of his statement. 6. Supply to the accused person a copy of written statement of charges. A. The following procedure should be adopted whenever a charge is preferred against a person arrested without warrant for any offense. As soon as the charge has been accepted by the appropriate police officer, a copy of the entry in the charge sheet or book giving particulars of the offense with which he is charged. So far as possible, the particulars of the charge should be stated in simple language so that the accused person may understand it. But they should also show clearly the precise offense in law with which he is charged. Where the offense charge is a statutory one, it should be sufficient for the latter purpose to quote the section of the statute which created the offense. The written notice should include some statement and the lines of the caution orally to the accused person in accordance with the judge's rules after a charge has been preferred. It is suggested that the form of notice should begin with the following words: You are charged with the offense shown below. You are not obliged to say anything unless you wish to do so. But whatever you say will be taken down in writing and may be given in evidence. B. Once the accused person has appeared before the court, it is not necessary to serve him with a written notice of any further charges which may be preferred. If, however, the police decide before he has appeared before a court to modify the charge or to prefer further charges, it is desirable that the person concerned should be formally charged with the further offences and given a written copy of the charge as soon as it is possible to do so, having regard to the particular circumstances of the case. If the accused person has then been released on bail, it may not always be practicable or reasonable to put forward a new charge at once, and in cases where he is due to surrender to his bail within 48 hours, or in other cases of difficulty, it will be sufficient for him to be formally charged with the further offence and serve with a written notice of the charge after he has surrendered to his bail and before he appears before the court. 7. Facilities for the defense. A person in custody should be allowed to speak on the telephone to his solicitor or to his friends, provided that no hindrance is reasonably likely to be caused to the process of the investigation or the administration of justice by his doing so. He should be supplied and request with writing materials, and his letters should be sent by post or otherwise with the least possible delay. Additionally, telegrams should be sent at once at his own expense. Persons in custody should not only be informed orally of the rights and facilities available to them, but in addition, notices describing them should be displayed at convenient and conspicuous places at the police stations, and the attention of persons in custody should be drawn to these notices. Nothing that I say in this episode should be construed as a legal advice. For legal advice, please contact an attorney of your choice. Here is where I will leave this episode for today. Thank you for watching, and I will see you in another episode.